This video will help you understand the differences between a note and a comment to guide your topic selection. Please note that your journal's definitions of notes and comments may be different from what is discussed here, so please defer to your editor-in-chief or managing editor if clarification is needed. For most law review and journal publications, a comment is an article about a recent case and its impact on an area of law. Comments tend to be easier to write because most of the sources you need are already included in the case itself. A note is an article that focuses on a current legal controversy or development. For example, it can be about a circuit split, inconsistencies between or across jurisdictions, an argument for legal reform, an analysis of the law in relation to other fields of study such as economics, history, or religion, or a discussion of the issues caused by a recently enacted law. Notes tend to be more challenging to write because the legal development or controversy needs to have occurred within the last year or so, not be moot before possible publication, and to have a clear central theme. If you are planning to write a comment, here are some preliminary considerations. To write a solid case comment, you need to have tension between the lower court and appellate court opinions. The lower court decision needs to have been reversed by the appellate court, which allows you to examine why the appellate court held differently. You can also write about an important case of first impression. It is not advisable to write a comment on a district court opinion. There is simply not enough substance, and it usually lacks the significance required for a comment. If you are planning to write a note, here are some preliminary considerations. You need to select a note topic that is current, relevant, writable, and advances the legal, social, or political discourse. Here are a few tips. Choose a topic that interests you. You are going to spend most of an academic year researching and writing your note. If you are selected for publication, you will most likely spend your summer and the next academic year polishing it. Once published, it will come up in job interviews for a long time. When selecting a topic, think about the time commitment and make sure it's something that will retain your interest. Second, the topic you select must contain a real legal argument, meaning there must be a legally significant opposing point of view for you to thoughtfully analyze. A note must contain a legal argument that can be subjected to analysis and interpretation. It is not just what you think about a topic. You need numerous supporting sources, as you should be footnoting almost every sentence. And remember, timing is everything. Initially, you may want to select a brand new controversy or topic. However, your topic cannot be so novel that there are no sources. There needs to be time for legislatures to act, courts to rule, and legal scholars to begin to research and write. On the other hand, your topic cannot be too historic. Your topic cannot be so old and overdone that you will bring nothing significant to the legal discussion. You should think about the fact that your note will not be published for more than a year after you begin writing, so choose something that will not be overanalyzed by that time. Bottom line, you should be looking for topics that emerged 12 to 24 months ago and are current, original, relevant to your journal, and arguable. Start thinking about your note topic now. It can be a challenge to come up with a topic that satisfies all the above criteria and is not preempted. Watch the Selecting a Note Topic and Checking for Preemption videos to learn more. Please contact your Lexis representative for further assistance.